Hello, and thank you for joining me. My name is Stephanie, and I'm a third-year occupational therapy student at Creighton University. I've put together this workshop as part of my doctoral capstone experience. My goal here is to prepare parents of children with disabilities to be confident advocates for their children. Understand that I am not a legal representative, nor will I be giving legal advice, though we will be discussing the law. First, we'll review parts of the Individuals with Disabilities Education Act. Part B covers free and appropriate public education from preschool through high school and to include transition services. We'll talk about evaluations and implementation of services and review your rights along the way. Then we'll get into early intervention services, which is covered under Part C of the law. Once we establish a basic understanding of all of that, as well as the processes and your rights, we'll dive a little more into how to become a strong advocate for your child. I understand that this can be an intimidating and emotionally challenging part of being a parent, so I want to help you feel prepared and confident in your journey. Let's start in with Part B. So let's have a review of FAPE. IDEA ensures that all children, including those with a disability, have a right to FAPE or free and appropriate public education. FAPE refers specifically to special education and related services that are provided at public expense, meet the standards of the state educational agency, and those that are provided in conformity with the child's individualized education plan or their IEP. We'll talk more about IEPs in a bit. So this applies throughout preschool, elementary school, and high school, middle and high school. A vital component of FAPE is the least restrictive environment. Children with disabilities must be educated in a general education classroom with typically developing peers as much as possible. They should only be pulled out for special education and related services when absolutely necessary to ensure their success. You might hear the term inclusion, which refers to a pretty similar concept. Before actually beginning the evaluation process, the requesting agency has to obtain parental consent. Just so you're aware, a screening is technically not considered an evaluation, so it won't require parental consent. So if your child's teacher or specialist has any concerns, they wouldn't have to get permission to conduct a simple screening. They could do something like determine more appropriate instructional strategies for effective curriculum implementation, or things like that. But they couldn't do like a formal assessment or anything like that without your permission first. Another important point here is that consent for evaluation is not automatic consent for special education and related services under IDEA. Parental consent has to be obtained again before those services actually start. In the event that a parent either refuses to give consent or fails to respond to requests for evaluation or to provide those services, then the school isn't held responsible for ensuring the free and appropriate public education. So understand that initially that falls on you as a parent. The school won't have to develop an IEP or host a meeting either, which makes sense if they're not doing an evaluation. It's a little bit different for children who are considered wards of the state. So the school has to make a reasonable effort to obtain parental consent, but if they can't locate the parents or if parental rights have been terminated or transferred by the courts and that transferee already gave consent, then consent is not required. This is another area of the law that tends to be a bit vague. It doesn't clearly define what constitutes reasonable effort, so that may vary between districts and how they interpret that. The initial request for an evaluation can come from a variety of sources. It could come directly from the parent. So if you're concerned that your child's participation and performance at school isn't what it should be, or if you think your child might have a disability. Another possibility is that your child was recently diagnosed with a disability and you want to seek supports within the school environment. The request could also come from a state or local educational agency, or in other words, a school or a state agency. There may be a variety of reasons a school wants to complete an evaluation. Sometimes it comes from a teacher who has observed some difficulties in the classroom, or it could come after state or district-wide assessments if the child is scoring well below average. In any case, after obtaining parental consent to evaluate, the school then has 60 days, unless otherwise specified by the state, to complete a full evaluation to determine A, if the child has a disability, and B, what their individual needs are. However, the school is not responsible for failure to complete the evaluation in that time frame if you don't produce your child for evaluation during that time. According to IDEA, you can request a reevaluation at any time if you think your child's education or related services needs have changed. So this includes if your child has made strides beyond their goals. We want to make sure that we are maximizing their potential and providing all of the appropriate services. Similarly, the local educational agency or a teacher can request a reevaluation as well. The law dictates that they have to occur at least every 3 years and no more than once a year unless the parent and the school agree otherwise. The law goes on to say that the IEP team has to try to obtain parental consent prior to initiating reevaluations, but if parents don't respond to reasonable measures, again, undefined what that actually constitutes, then they can begin the reevaluation process. So this is a little bit different here. You have the right to provide consent before they ever interact or evaluate with your child initially, but if you've already given consent for evaluation and your child has been receiving services, technically they can do that reevaluation if you don't tell them otherwise and they have tried to reach you several times. According to IDEA, schools have to use a variety of tools and strategies that are technically sound to determine whether or not your child has a disability and what the appropriate content of your child's IEP should be. That I in IEP again stands for individualized. So it makes sense then that the school would have to have many assessments available to target your child's unique needs. The law goes on to say that the evaluation materials must not be discriminatory on a racial or cultural basis. They have to be valid and reliable, and they need to be administered by a qualified professional. Some of the assessments are specific on who can administer them. They should be administered in a language and form that is most likely to yield the most accurate information on what a child knows. That piece is very important. It helps to ensure that the team is evaluating a true disability and not that the child just didn't understand the questions because of something like a language barrier. IDEA also specifically says a child has to be assessed in all areas of suspected disability. A lot of times it can be difficult to decipher why a child is struggling academically. It could be one isolated thing, but oftentimes it's a combination of hurdles. So it's important to get a really comprehensive look at the child to make sure that all of their needs are met. IDEA states that the IEP team has to review all existing evaluations, including any information provided by parents, any assessments the student has taken, and observations by teachers and related service providers during initial and reevaluations. All of this information is then used to determine eligibility, to understand the child's unique needs, and to create or adjust the child's IEP. If you have outside evaluations, it's up to you if you want to share them, but it could provide some very valuable insight for the school team. You can either send them a copy yourself, or you can sign a release that allows whoever conducted the evaluation to send it and communicate with the school directly. As a parent, you also have a right to request further assessment if needed. Again, the school is required by law to investigate all areas of suspected disability. IDEA also says that the school has to inform parents of this right, but the law doesn't specify how they have to inform parents. And many schools give parents an informational packet, either at the beginning of the process or again before an IEP meeting. But here's the thing. Everyone's busy, and a lot of times people don't take the time to read through all of those documents, but it's so crucial because that's where a lot of parental rights like this are listed. So I encourage you as the parent of a child with a disability, please find the time to sit down and thoroughly read through anything that's given to you. Following an evaluation comes eligibility determination. IDEA restates that eligibility is determined by the IEP team and also specifies that a copy of that evaluation has to be given to parents. It specifies that the lack of proper instruction and lack of English proficiency don't qualify the student as a student with a disability. That's again why it's so important that assessments are given in a familiar language and in a way that's going to yield the most accurate information about what the child knows. This section of the law also requires a reevaluation to determine that a child no longer has a disability. Now, if the child graduated from secondary school with a regular diploma, or if they're exceeding the age of eligibility for FAPE, a reevaluation doesn't have to occur, but the school has to provide a summary of the child's academic achievement and functional performance. The summary should also include recommendations that assist the child with their post-secondary goals. So it's not like they're just completely left hanging and that's just it. The school wipes their hand and walks away. They still have to provide some sort of kind of transition materials, if you will. So what is an IEP? If a child is deemed eligible for special education and related services, the team will develop an individualized education plan. Part B defines an individualized education plan as a written statement for each child with a disability that is developed, reviewed, and revised regularly. It needs to include a statement of present levels of academic and functional performance and achievement. And basically, this is a statement that reflects how the child is doing with what's currently in place, if anything. The IEP will also include a statement that describes how the child's disability affects their participation and performance in general education. And that's really meant to help define what supports and services that child may need. Additionally, it'll include a section of measurable academic and functional goals. These goals need to relate back to those child's needs. The IEP needs to define how and when progress on these goals will be monitored and reported. As a parent, you have a right to these progress reports. So if it helps you, make sure you set some sort of calendar reminder so that you can check in and request a copy if it hasn't been given to you. Progress reports may provide good evidence if you believe your child's IEP needs have changed mid-year and you want to request changes. Other portions required include a statement of special education and related services, supplementary aids and services, program modifications, or supports for school personnel. There should be a statement about the projected start date, anticipated frequency, location, and duration of these services and modifications. And lastly, the IEP needs to include all of the accommodations necessary to measure achievement and performance. The IEP team has to justify their decision for the child to participate in alternate assessments if applicable. All of this is meant to create a very clear picture of what the child needs to be successful in school. If the IEP team includes any services or accommodations that will take the child out of the general education setting, there has to be a statement that describes the extent to which they'll be pulled out and a justification as to why. Again, this goes back to least restrictive environment. For older children, there also has to be a section that covers the transition piece. IDEA specifically says that transition services must be addressed and implemented no later than 16 years of age. So if your child is turning 16 in the next year, those provisions should be included in that next IEP so that they're in place by the time they turn 16. And here, the key word is no later than, meaning if it's a priority to you and your child, start sooner. 14 is generally the youngest age transition planning begins. So if you feel ready for that, if you want to get that ball rolling, bring it up to your team. This section, the transition planning section, has to clearly state measurable post-secondary goals and describe the transition services required to achieve them. If during a year any participating agency fails to provide the services to meet those goals, the IEP team has to reconvene to determine alternate strategy to meet those goals. So again, it's not one of those things that they can just walk away from. It's in the IEP, they have to adhere to that. Speaking of the team, let's cover who is on it real quick. So obviously the child themselves is considered part of the team, though typically they don't participate in meetings and the planning until they're a bit older. It's really at the discretion of the team and you as the parent. You are always a part of the team regardless. You have valuable insight on how your child is functioning, both at home and sometimes at school, and what concerns you have related to their educational needs. The IEP team also includes the regular education teacher if your child's part of a general education classroom, in addition to at least one special education teacher, a representative of the school, and somebody who is qualified to interpret instructional implications of evaluation results. This person could be a member that we already mentioned or a related service provider like a physical or occupational therapist. Oftentimes, each person or provider will explain whatever component of the evaluation and related portion of the IEP team, or I'm sorry, of the IEP that they completed. And that really allows you as the parent to ask clarifying questions to the most appropriate person and helps you to foster a relationship with those individual service providers. Typically, all of these team members are required to attend IEP meetings. However, a member may be excused either in whole or in part from the meeting if you and the school agree that their attendance isn't necessary. If their part of the IEP team is going to be modified from the previous one, they need to submit their input in writing to you and the team. I think it's really more common for providers to kind of go over their part of the evaluation and the IEP and then leave if they need to rather than submitting written input. But again, remember that ultimately that is kind of up to you because IDA requires their attendance unless you agree otherwise. If you are planning on bringing up new concerns or asking for something specific and want them to be there, just make sure you let that be known at the beginning of the meeting or even before. In developing an IEP, the law says that the team has to consider first and foremost the strengths of the child. They also need to consider your parental concerns, evaluation results, and academic, developmental, and functional needs of the child. Typically, those needs are going to be identified through that evaluation process and input from everybody on the team. IDEA says that the team should consider language and communication needs for children who have vision and auditory impairments, and for those for whom English is not their first language. Another consideration should be the use of positive behavioral interventions and supports. The law states that these should be in place when a child's behavior is affecting their own learning or the learning of others around them. The regular education teacher should have input in these plans, which makes sense because they'll likely be the ones implementing the plan. As mentioned, your child's needs could change during the year. So if you and the IEP team agree, you can create a written document to make adjustments in lieu of an in-person meeting. But if you are more comfortable with that meeting, ask for it. That is your right. However, if the IEP does have to be revised at least annually. IDEA says that the review should address any lack of expected progress toward annual goals and in general education curriculum. The team should also review results of any reevaluations, any additional information that you provide about the child, review their anticipated needs in the coming year, and any other matters that pertain to their educational success. As mentioned, some IEPs include behavior plans. When behavior requires intervention, a series of events may happen. One of the major things is determining whether or not the child's behavior is a manifestation, or in other words, an expression of their disability. IDEA is very clear in stating that during any proceedings, such as a manifestation hearing, the child is to remain in their current placement or be assigned to a public school program given parental consent. Keyword there, given parental consent. IDEA also says that school personnel have the authority to change the placement of a child with a disability to an alternative setting if their behavior violates a code of student conduct. In this case, the local education agency, you and the IEP team would have to meet collaboratively to determine if the behavior was a result of the child's disability or if it was a direct result of failure to implement the IEP appropriately. If the group decides that it was in fact a manifestation of disability, then IDEA requires that the team conduct a functional behavioral assessment or FBA and implement a behavioral intervention plan if they had not done so previously. If a plan already exists, then they have to determine appropriate modifications to prevent reoccurrence of that behavior. IDEA states the child should return to their original placement following the decision unless you and the school agree to change their placement as part of that behavioral intervention plan. Understand as a parent, it's your right to be part of these meetings and decisions. Don't be afraid to use your voice to bring up any concerns that you have. This really is meant to be a collaborative process. Regardless of whether the behavior is determined to be a manifestation or not, your child may be moved to an interim alternative educational setting for up to 45 days if they carry or possess weapons, if they knowingly possess or use drugs, sell or solicit sale of controlled substance, or if they inflict serious bodily injury upon another person at school. IDEA requires that the school inform parents of disciplinary action the same day it occurs, and the school at the same time has to provide a copy of procedural safeguards, which again contains a lot of your parental rights. If you disagree with the placement or manifestation decision for your child, you can file an appeal. The school may also request a hearing if they feel that keeping the current placement would put others at risk for injury. A hearing officer then has the right to return your child to the placement from which they were removed or order a change in placement to an interim setting for 45 days if they believe there is risk of harm. In that case, your child would remain in that interim placement until the officer made a final placement decision or until the 45-day period expired. IDEA requires that the hearing itself take place within 20 school days. The final determination must be made within 10 days of that hearing. If the school was aware your child had a disability before that behavior occurred, but your child didn't qualify for special education and services, the child is still going to be afforded all of these protections under this law. The law states that schools are deemed to have prior knowledge if you, the parent, or teacher had submitted written concerns to supervisory and administrative personnel that your child may need special education, if you requested an evaluation, or if the teacher or school personnel had previously expressed concern regarding a pattern of behavior directly to the special ed director or other supervisory personnel. If you refused evaluation or services, or if the evaluation found that your child didn't have a disability, the school will be deemed not to have prior knowledge, which would mean your child would be disciplined similarly to children without disabilities. Now, sometimes requests for initial evaluation are made in response to behavioral occurrences. If a request is made during the disciplinary time period, IDEA says the evaluation should be expedited. If it's then determined that the child has a disability, the child will be granted services and remain in their current placement as appropriate. One last point I want to make here. IDEA specifically states that the law does not protect against nor encourage schools not to report crimes to the appropriate authority, meaning the school has every right to call the authorities if a serious crime was committed despite your child's disability status. Now, this doesn't mean that they will, but they certainly can. The law obligates the reporting agency to turn over copies of your child's IEP as well as disciplinary reports for consideration as well. And that would be all of their disciplinary reports, not just the one regarding this specific incident. So whether it's in regard to manifestation or something else, the fact is that sometimes there's going to be disagreement between parents and schools. Under IDEA, state or local educational agencies that receive financial assistance have to have established procedures, which include mediation, for dispute resolution. The following elements should be covered. They should contain procedures that ensure the mediation process is voluntary by all parties, is not used to deny or delay your right to use due process hearings, and is conducted by a qualified and impartial mediator who is trained in effective mediation strategies. The law requires each state to maintain a list of appropriate mediators who are knowledgeable about the laws and regulations related to special education and related services. It also specifies that mediation meetings need to be scheduled in a timely manner and that the state bears the cost of mediation. Again, this is supposed to be a free and appropriate public education, right? So there are things in place to protect you in the schools and financially if you run into trouble. IDEA requires provisions that local and state educational agencies offer schools and parents who don't want to pursue mediation a chance to meet with disinterested parties at the convenience of the parents. The goal here is going to be to educate you on the benefits of mediation and encourage you to consider it, but still you do not have to pursue mediation if you don't want to. Should you and the school come to an agreement through mediation, a written document has to be established that states all of the discussions that occur through that mediation process remain confidential, and it states that they can't be used as evidence in any subsequent due process hearings or civil proceedings. So if you make an agreement through mediation, that's kind of it. You cannot use any of that in another avenue like due process. The agreement has to be signed by you as well as a representative of the agency who has binding authority to make the agreement, and it has to be enforceable in any state or district court in the US. So once you initially file a complaint, a preliminary meeting will occur between you and members of the IEP team that are knowledgeable about the facts of the case, and it has to occur within 15 days. A representative of the educational agency who has that decision-making power has to be in attendance. IDEA states that the district may not bring an attorney unless you request to bring one of your own first. Again, the goal here is to resolve disputes collaboratively and civilly as possible. At the meeting, you'll be asked to present the facts related to your complaint. The district will then attempt to resolve the issue. Any agreement made can be voided by either party within 3 business days. The meeting may also be waived if both parties agree in writing or agree to pursue mediation instead. If you and the local educational agency can't reach resolution within 30 days of the complaint being filed, then it will go to due process. Both parties will share any evaluations and recommendations they plan to present to the opposing party at least 5 days before the hearing. The law does grant the hearing officer authority to ban introduction of new materials unless the other party consents. The hearing officer can't be an employee of an educational agency that's involved with your child, and they cannot have a personal or professional conflict of interest. According to the law, they need to have the ability to understand the legal interpretations of IDEA and the knowledge to conduct hearings and render and write appropriate decisions. The due process hearing is only meant to cover the complaint filed. IDEA specifically says that the party requesting the hearing can't raise additional issues. Only those discussed in that initial complaint will be covered. Finally, the law states that a hearing has to be requested within 2 years of violation, unless you as a parent were prevented from filing because the local educational agency falsely represented resolution, or they didn't inform you of your rights to due process. Again, that's one of those things that is commonly included in your procedural safeguards. On to the decision. A hearing officer may determine that a child didn't receive FAPE only if procedural inadequacies impeded your child's right to FAPE, significantly impeded your opportunity to participate in the decision-making process regarding FAPE, or caused deprivation of educational benefits. IDEA says that any involved party may appeal the decision to the state. An officer will then review findings and decisions and make an independent decision thereafter. During this process, any party has the following rights. 1, they have the right to be accompanied or advised by counsel and individuals with special knowledge and training with respect to children with disabilities. They have the right to present evidence and confront, cross-examine, and compel attendance of witnesses and the right to written or electronic, if you consent, findings of facts and decisions. This also has to be made available to the public and transmitted to the advisory panel. Beyond an appeal, either party may pursue civil action if they're still dissatisfied with the final decisions in any state or district court in the US. Parties have 90 days after a hearing decision to raise action unless an alternate timeline is established by the state. The court will receive records of administrative proceedings, hear additional evidence as requested by the party, and grant relief as deemed appropriate. The courts also have authority to grant reasonable attorney fees to the prevailing party if either party or their attorneys are pursuing litigation for inappropriate purposes or if litigation is frivolous or unreasonable. In any case, they may grant fees to prevailing parents. So, key here, you want to make sure if you're going to go through this process, you are very grounded in your decision to do so, and that everything you're bringing to the table is fact-based and not sort of driven by emotions. So due process starts with either the school or parents filing a complaint. A copy is given to the opposing party as well as the state agency. And IDEA says that the initial complaint needs to include the name of the child, their residential address, the school that they attend, the nature of the problem, as well as a proposed solution if appropriate. Only facts and evidence can be included here. It's not a place for opinions or assumptions to be expressed. Each state is then required by law to provide an example. So if you ever find yourself needing to use this process, make sure you look up the example in your state so you can use it as a reference and as guidance to fill out your own. IDEA further breaks down what has to be included in the due process complaint. In addition to the proposed action or refusal of action, the complaint should include an explanation of why the agency chooses to or not to take action, supported by a description of the evaluation procedure, assessment, record, or report that the agency based the decision on. This helps to ensure that neither party is arbitrarily making decisions or claims. Again, they have to justify their thinking. Due process complaints need to include a statement that the parents of a child with disability have protection under procedural safeguards and information on the process for obtaining them, as well as sources for parents to obtain assistance in understanding IDEA Part B. The law can be very confusing, and in a lot of places it doesn't use parent-friendly language. So if you run into issues, please be sure you ask your school to connect you with those supports. The more you know and understand as a parent, the better you can advocate for your child. So due process complaints also have to include a description of other options considered and IEP team, why the IEP team deemed them not appropriate. They should explain any other factors that are related to the proposal or refusal as well. IDEA states that if a local educational agency has not sent prior written notice to you regarding the subject matter in your complaint, then the agency has to send a response within 10 days. Similarly to what we talked about earlier, the response needs to include an explanation of why the agency proposed or refused to take a specific action, a description of other options considered, including why they were rejected, a description of the procedure, assessment, or record or report that they used to base their decision on, and a description of any other relevant factors. And that has to be sent again within 10 days. According to the law, a hearing officer will determine and inform parties if the notice doesn't meet these requirements. So IDEA Part B really protects you and your child in many ways, as we've seen. The main rights we covered are listed here, but understand that there are so many more. I'll remind you again, I know I'm probably beating a dead horse at this point, but it's very, very important that you review your procedural safeguards. They contain so much valuable information. The big overarching one is that your child has a right to receive a free and appropriate public education. As a parent, you have a right to consent or deny evaluation or any specific services. You have the right to understand how this process works, so make sure if you need to tap into those additional resources, ask your IEP team. Furthermore, you have every right to be an active participant in the IEP development. You should be given the opportunity to provide input and participate in team decisions. Finally, should anything go awry, you have options to file complaints and appeal decisions. So that's kind of the basics of Part B, and education and services in the school setting. Now we'll take a look into Part C, which describes early intervention services for infants and toddlers with disabilities, including those who are at risk, even if delays have not yet occurred. So according to IDEA, early intervention services are those that are provided under public supervision that are designed to meet the developmental needs of infants and toddlers with disabilities as identified by an individualized family service plan. They must meet the standards of the state in which they're being provided. So the IFSP will address one or more of the following areas: physical, cognitive, communication, social or emotional, or adaptive development. The IFSP is essentially the early intervention version of an IEP in a school setting. Part C breaks down what a family is entitled to during the early intervention process. So first, the infant or toddler and their family is entitled to a multidisciplinary assessment of the child's unique strengths and needs, as well as identification of the services required to meet those needs. The assessment should be family directed. It needs to consider the family's resources and priorities, as well as their concerns to help identify what supports and services the family needs to meet the developmental needs of the child most effectively. Once evaluation is complete, there has to be a written individualized family service plan that specifically outlines all the services required, including transition services when the child goes into either pre-K or kindergarten. As a parent, you have the right to give input and be actively involved in this process too. You know your kid and your family the best. IDEA dictates that the plan has to be developed within a reasonable time after assessment. So again, there's that term reasonable, doesn't actually define what it means. You do have the option to consent to begin service prior to the full plan being written if you choose to do that. IDEA dictates that reevaluation needs to occur annually. Additionally, the family should be provided with review at least every 6 months or more if necessary. At this age, we know children are developing and changing so quickly. So if you feel like your child's needs are changing before a scheduled review or evaluation, just let your team know. It's always better to make the appropriate adjustments to maximize your child's potential. Each IFSP has to include the following elements. First, it should include a statement that describes the infant or toddler's present levels of development in all of those areas we talked about earlier: physical, cognitive, communication, social or emotional, and adaptive development. And they must be based on objective criteria. It needs to have a statement of the family's resources, priorities, and concerns as it relates to enhancing the child's development. Another statement should reflect the child's goals and outcome measures that are going to be used to track progress. Goals here have to include a pre-literacy and language component. The law requires services to be delivered in the most natural environment as possible, so things like home and community settings that the child is already involved in. The IFSP has to clearly state the extent to which services won't be provided in these natural contexts and justify why. The plan has to detail early intervention services that are based on peer-reviewed research and include frequency, intensity, and delivery method. It's important that early intervention providers are using the most current evidence-based strategies and treatment approaches to really maximize benefit to the child. In addition to describing what they will do, the plan should define when in terms of anticipated start date, length, duration, and frequency of services. Finally, the plan should identify who their service coordinator will be. This person will be in charge of implementing the plan and coordinating with the appropriate agencies, including during that transition period. As a parent, you'll likely be in frequent communication with them as things come up. The law requires that the IFSP be fully explained to parents. It's also your right as a parent to choose which services to consent to and which you do not consent to. The team must take that into consideration and only provide those for which you consent. And by the way, saying no to one service does not jeopardize your child's eligibility for another service. So just keep that in mind. Again, you know your child and you are in the driver's seat. As with Part B, eligible children are entitled to receive services in all needed areas. Feel free to pause here and screenshot if you need. I'm not going to cover every single thing listed here, but I would like to note a few things. The law is very clear about medical services. They can only be provided for documentation and evaluation purposes, not for treatment purposes. I didn't mention it before, but the same is true under Part B. Here, transportation and related costs covers anything that's necessary to enable the infant or toddler and their family to receive any of the other services. For example, if the family doesn't have independent transportation to an audiology clinic, IDEA would fund some sort of transportation service to get them there. Part C is clear that it's ultimately up to the parents to decide if their child is going to continue receiving services through early intervention or if they're going to transition to preschool once the child turns 3. Technically, they can receive early intervention services until they're eligible per state law to enter kindergarten. The state cannot have policies that prevent a child from continuing early education services if that's what the parent wants. But if that's what you choose, the state's also not obligated to provide FAPE. IDEA requires that states provide an annual notice to parents of children with disabilities that includes a description of their rights to elect to receive early intervention services, as well as an explanation of the difference between the two options. So it has to detail the types of services, the location where they'll be provided, procedural safeguards, and the possible costs of each choice. Early intervention services are still required during that transitional period, and they have to include an educational component that promotes school readiness, pre-literacy, language, and numeracy skills. Again, this law is intended to maximize educational potential. So even in the early intervention stages, the focus still has to be on some of those more academic type things. As a parent, you are obligated to provide written consent to the state of your decision between 9 and 90 days of services ending. So if your child's turning 3 on February 1st, you can inform them 90 days prior to that or up to 9 days prior to that. But either way, they need to know so that they can plan and prepare. All early intervention services outlined in the Individualized Family Service Plan have to continue, as I said, through that transition process. So let's quickly review what we covered. I want to stress that this is not an all-encompassing list by any means, and you'll notice a lot of these rights mirror what we talked about with the IEP services too. We talked about how, as a parent of an infant or toddler with disability, you have the right to an evaluation if your child has a known disability or if they're at risk, even if that child has not shown delays yet. You have the right to consent to services prior to evaluation and prior to initiation of services. Once the team determines what the child qualifies for and presents the Individualized Family Service Plan, you can choose which to consent to and which to deny. Through the process, you have the right to be present and active as you have the most knowledge of your child's strengths and weaknesses. If those things change, you'll always have the option to request a meeting and make adjustments. Finally, you have the right to be informed. If at any time you don't understand something, you have the right to have the IFSP fully explained to you. So make sure you're getting in contact with that case coordinator. Now we've covered the basics of the law. Awesome. We get to switch gears and we'll start talking about how to be an effective advocate for your child. Organization is very, very key to this process. As a parent, you'll want to have as many things in writing as possible. Keep it in a folder, could be digital or print, whatever works best for you, but it should include your child's progress reports. Try to also save some work samples throughout the year that reflects your child's progress or lack thereof. For example, if they have some sort of handwriting goal, make sure you're keeping samples so that you can um, show progress or determine if they are not having changes. If they have a math goal, make sure you're keeping math homework, things like that. Make sure everything that you have is dated too. If your child has a behavioral intervention plan, you'll want to make sure that you keep track of any incidences, strategies that have been trialed, and anything else that kind of relates to the behavior piece. If they have accommodations, communicate with teachers so that you can keep notes of how the child performs with them. All of this will serve as data to help justify specific services or accommodations that you ask for. It can be difficult to get some IEP teams to agree to your parent request, but if you have something in writing that supports how and why your child will benefit, it becomes a lot harder for them to deny your request. Try to communicate through written methods as much as possible. It's best to make requests for meetings, IEP adjustments, and reevaluations through email so that there's a clear record and timeline. Sometimes phone calls are easier if you're just problem solving or discussing something specific. I would recommend just jotting down the date and a summary of what was talked about for your records as well. Unfortunately, as we discussed, situations may arise where you find yourself needing to file a formal complaint or appeal decisions that you don't agree with. And having a file ready and organized with all of this information to support your claim will make the process so much easier and less stressful. You won't be scrambling for it when you are already feeling frustrated and overwhelmed. So, in relation to evaluation IEPs, here are some more strategies for you. Your job as a parent is to advocate for your child to be fully evaluated. If there's an area you feel like the team didn't fully investigate or didn't address at all, make sure you request that they do so. And it's not your job as the parent to determine how it gets evaluated. That is on the team. Schools can't just say, oh, well, we only have XYZ assessments, um, so that's what we have to use. If they don't have an appropriate assessment or way to evaluate something, they are required by law to obtain it. Another strategy is to stick to the facts. This can be an emotional process. As a parent, I'm sure that you want nothing more than the very best for your child. And sometimes, let's be honest, our mama bear and papa bear sides can come out. But as much as possible, really stick to fact based claims and use your data to ensure that you're making reasonable requests. Speaking of being reasonable, understand that there is no limit on the number of goals your child can have in their IEP, but the team has limited time and resources. So they may have to prioritize which they focus on more, but your team can't tell you that, oh, we can only have this many goals. If it's a priority to you and it directly relates to your child's participation and performance in school, there should be a related goal. And like everything else, transition planning varies greatly between districts. I encourage you as a parent to initiate conversations about transition planning as early as when your child's 14, but no later than that 16, age of 16 as required by law. Starting earlier grants your child the most opportunity to prepare for life after high school. Once transition planning is included in the IEP, the school's required to invite participating agencies to the IEP meeting to further clarify their role and sort of explain to you how they're going to support your child. It's a good idea to clarify with the case manager prior to the meeting that they have been invited. Similarly, if you're a parent of a child transitioning from early intervention services into preschool or kindergarten, the school is required to invite a representative from the early intervention side of it. I want to be sure to clarify here, these parties aren't required to attend. The school is just required to invite them. Finally, remember that IDEA states that placement is the last step. The team may have an idea of where they think would be the most appropriate placement for your child going into the meeting, but that final decision should include you and should occur after the team has discussed all the relevant evaluation information and the goals. Don't be afraid to ask questions and voice your concerns if you disagree with what they're proposing. I know. You hear it all the time. I hear it all the time. Self care, take time for you. It's easier said than done for most of us, but it's so darn true. We can't pour into others and be the best advocate for our kids if our cup is empty. So, whether it's sitting in silence for 5 minutes at the end of the day before you climb into bed, exercising, taking a bath, whatever that looks like for you, please find time to take care of yourself so that you can put your best foot forward for your child. My next piece of advice is to mentally prepare before meetings. Again, this could look a little different for each of you. IEP meetings can inherently feel negative and it can feel discouraging. The team has to identify all of your child's weaknesses so that they can justify as much support as possible. Try to remember that everybody's goal is for your child to be successful, and they most likely have your child's best interests at heart. That being said, like with any other relationships, conflict may arise. So please don't raise complaints or concerns initially when you're upset. Jot down your thoughts and write the email the next day. If you need to, have somebody read it over to make sure that it sounds professional and reasonable while still getting your points and concerns across. You want to do your part in maintaining a positive working relationship with all the IEP team members. Other tips and tricks. One thing that I've seen and absolutely loved is to have a vision statement for your child. It doesn't have to be incredibly specific and it's not set in stone. But what do you want for your child? As your child grows and gets older, involve them. Update it to reflect what they want to do with their life. If you feel so inclined, share it with your child's IEP team so that everybody shares this and buys into this long term vision and these goals. It's also a good idea to identify your child's strengths and weaknesses before the meeting so that you're more prepared to provide input and request further evaluation as necessary. On that note, request a draft of an IEP before the meeting so that you can review it. It's quite a bit of information to take in, so having a copy ahead of time really allows you to mull it over and decide what you might want to add or change. This also makes the meeting more efficient. You shouldn't feel rushed through anything during the meeting. Remember, as a parent, you have a right for everything to be fully explained to you. So if you feel like the meeting's going over or you are starting to get rushed through some things, it's perfectly appropriate for you to request a continuation meeting to ensure that you have time to ask all of your questions and address everything appropriately. After the IEP team meets, send a summary letter to everybody that details any changes that were discussed. Not only does this serve as a reminder for them to update it before submitting it, but it also helps hold them accountable to implement the plan that you all agreed on. So, those are my advocacy strategies and tips. And with that, we've reached the end of this workshop. I hope this was helpful for you and that you feel more prepared to advocate for your child. Your first time through the process, it might feel intimidating, but you've got this. You'll learn the ropes and you'll feel more confident the more involved you get. Thank you so much for joining me, and I wish you and your child the best in this journey.